Nassau County, New York. Immigration lawyer. New York is home to more than 4.5 million immigrants, which is more than 1 in 5 residents in the state. In New York City and its suburbs, immigrants make up about 37% of the population. With so many people building lives and careers here, the system gets crowded and the rules can shift without much warning. When critical steps are overlooked or delayed, the consequences can be serious. Immigration matters often turn on the category you qualify for, the forms required, and the evidence that supports your eligibility. Employment-based cases may involve EB-2 or EB-3 options tied to education, skills, job offers, and required certifications. For EB-2, a traditional case can involve an advanced degree and a full-time job offer that meets prevailing wage standards. For professionals whose work benefits the United States as a whole, a national interest waiver can remove the job offer requirement while still filing Form I-140. NIW filings often focus on a record of past achievements, a well-defined proposed endeavor, and proof that granting the waiver advances national interests. EB-3 can apply when a position requires at least 2 years of training or a U.S. bachelor's degree, and it typically requires the employer to complete perm labor certification first. For preference categories, timing can depend on your priority date and the monthly Visa Bulletin. Priority date management matters because the system does not always move in a straight line, and a filing window can open and close based on bulletin movement. Strategy can also involve cross-chargeability, priority date retention, or reclassification approaches in the right circumstances. Some individuals may qualify under extraordinary ability pathways, including EB-1A, where a U.S. job offer is optional and the petition can rest on past record and sustained acclaim. An O-1 visa can serve as a faster non-immigrant option that keeps you in the United States for up to 3 years while a permanent case proceeds or while you complete a specific project. In these filings, exhibits should connect directly to the legal criteria and explain impact clearly rather than relying on volume alone. Family-based green card petitions can be emotionally demanding, especially when you are filing for a spouse, parent, or child. Immediate relatives of a U.S. citizen are not subject to a visa cap, but accuracy, supporting documents, and consistent filings still matter. Preference categories have annual limits, and monitoring the Visa Bulletin can help you know when it is time to act. If a spouse has a conditional green card from a marriage under 2 years, removing conditions with an I-751 can require strong evidence of a real shared life or a waiver filing depending on circumstances. When applying for a green card, the process may involve adjustment of status in the U.S. or consular processing abroad, and the right approach depends on the facts of your situation. Interview preparation, medical exam timing, and properly completed forms can reduce the risk of delays or denials. If problems arise, RFEs, NOIDs, and other notices can require fast, organized responses under tight deadlines. Waivers like the I-601 or I-212 can come into play when past immigration history creates barriers to re-entry or adjustment. Appeals to the AO or BIA, and federal actions such as mandamus or APA litigation, may be options in certain situations. A lawyer can help you understand which category fits, what evidence matters most, and what deadlines you cannot miss. An attorney can also help track the Visa Bulletin and explain what monthly movement means for your next step. For many people, working with a law firm can bring structure to a process that otherwise feels uncertain. Shankar Associates PC describes a process built on clarity, accessibility, and personal handling of cases by senior attorneys. If you want guidance that stays focused on your filings from start to finish, a law firm can help keep your case moving and respond when action is needed. A second lawyer can be especially valuable when timelines are tight and the stakes are high. A second attorney can also help you prepare for interviews and avoid common filing mistakes that create delays. Shankar Associates PC is here to help you take the next step in your immigration journey, and you can contact the law firm at 800-461-1467 or visit 518 Plainview Road, Plainview, New York, 11803, United States.